Okay, in Chapter 7, we're going to continue looking at victims and other parts of the criminal justice system. Okay, so remember, where do victims begin to get their rights as this kind of starts to change and the way we look at victims starts to change? Well, sometimes this comes from police policies that other criminal justice agencies put into effect that are very innovative. It could come from laws that are passed at the city, county, or state level. It comes from 6th and 7th Amendment rights, the National Crime Victims' Rights Act, and case law. So case law means as cases go before judges and judges make decisions, that becomes case law that is then followed within that jurisdiction. So sometimes people look at this as a zero-sum game, okay? Which means then that there's only so many rights to go around. And when victims gain rights, it comes at the expense of criminals, the criminal justice systems, offenders, or officials. So let's look at the idea of rights gained at the expense of offenders. So the theory here is that victims' rights should come at the expense of an offender's rights. We want to shift balance of power away from offenders and towards victims. Here we could see a list of rights gained at the expense of suspects, defendants, and prisoners. This can include things like denial of bail, protection from further harm, to be reasonably protected during pretrial release. So that could happen through an order of protection. And therefore, accompanying that would be penalties for harassment or intimidation or continuing to contact the victim. In terms of defenses, in order to be assured that defendants cannot avoid imprisonment by pleading not guilty by reason of insanity through the substitution of this guilty but mentally ill plea. Okay, so what this means is the person is found guilty and that mental illness played a contributory role, but basically it's the same thing as a guilty plea except that the offender is mandated to treatment. In terms of privacy, this may impact things like medical records and statements that a victim has made to a counselor, that those could remain confidential even if requested by the defense during discovery. In terms of evidence, the idea that defendants cannot benefit from the exclusion of illegally gathered evidence by having all evidence obtained by the police in good faith declared admissible. In terms of the offender's age, we see this happening with juvenile offenders, being assured that they're not able to escape full responsibility for serious crimes by being, and what they do here is often transfer them to adult criminal court. In terms of restitution, receiving mandatory repayments from convicts who are put on probation or parole. In terms of appeals, to not appeal sentences that seem too lenient. We don't allow, generally speaking, offenders to profit from the crimes that they have committed. So that could be in terms of writing a book or something along those lines. And then finally, an abuser's tax, to have penalty assessments collected from felons, misdemeanors, and traffic law violators to pay for victim services, compensation, and assistance programs. We can also talk about then rights that are gained at the expense of the criminal justice system. This theory is based on the idea that the social system is partly at fault for crime in America. Therefore, states are obligated to minimize the suffering of victims, and victims should be made whole again, even if the offender is not captured and apprehended. And here we have a list of these. To be read your rights as soon as a crime is reported, or to be provided with written information about obligations, services, and opportunities for protection and reimbursement. To keep them abreast of what's going on with progress in their cases, to let them know when an arrest warrant has been issued or someone's been arrested. To be notified in advance of all court proceedings and changes in court appearances. To be provided with a safe, secure waiting area in the courtroom, separate from those used by the defendant. For the prosecutor to explain to the witness, his employer, that the victim should not be penalized for missing work because of court appearances. They may also intervene with creditors, such as banks and landlords, when financial losses might delay their ability to make those payments. To be notified that someone who has been arrested has been released on bail. To be notified that there's a plea agreement. To be notified of the verdict and sentence. to be notified if the convict is going to be allowed to be on work release, to be notified of parole hearings, pardons, release of a prisoner, prison escape, to make sure that stolen property that's been recovered and held as evidence is returned promptly, to repay victims first from any funds collected by the court before any other legal obligation or fines are paid off. And finally, to be reimbursed for out-of-pocket expenses for medical bills and lost wages coming from injuries inflicted during a violent crime. And then finally, rights gained at the expense of offenders, the system, or both. So this includes things like victims being able to participate in bail setting arrangements, plea negotiations, sentence hearing decisions, and parole board appearances. So what are some issues here? Do these formal rights apply to individuals who do not fit the profile of completely innocent victims? What are the consequences for non-compliance with the aforementioned victim rights? Well, there aren't any. In the past, in colonial America, the victims were basically responsible for hiring their own attorneys to prosecute. Do these processes result in differential handling or differential access to justice? Also, what about providing an advocate for a victim, providing them a guardian ad litem? Guardian ad litems are often appointed to juveniles when they're working their way through the system, and a guardian ad litem is someone who's supposed to look out for the best interests of the person they represent. So, within a jurisdiction, the chief law enforcement officer is the prosecutor, right? That's going to be the person who decides what charges are filed, if any, and then is responsible for bringing that case to court. There's some ways that they could best serve victims. So one thing they could do is really keep victims informed of what's going on with the case, okay? Where is it? When is court happening? Things like that. Kind of let them know what to expect. They could support victims with judges, bail, continuances, negotiated pleas, drop charges, sentences, and restitution. They could also try their best to protect the victim from harassment, threats, injuries, and intimidation. They can try to resolve the case as quickly as possible and then assist them in recovering property that the police has been holding as evidence. Most prosecutors' offices have a victim witness assistant project, and they have people who worked as a victim witness advocate. And their job is to support the victim or support the witnesses, to address any complaints they have, to keep them apprised of what's happening in the system and what they can expect. And the point here is to restore victims' faith in the criminal justice system. The belief here is that if you're there to support them, then they're also more likely to show up in court, which is going to help you gain a conviction. What we want is for them to be able to intervene as soon as possible and to also help connect an injured party with whatever relief or assistance might be necessary for them. Information about hotlines, shelter, food, counseling, transportation, changing locks on your house. So some of the services they often provide translators. They can help you recover that lost property, make referrals to social service and mental health agencies. They could provide information about how victims' compensation works and help you with that process. So in 1974, only about 35% of DA offices routinely notified felony victims of case outcomes, but by 1992, that was 97% of them, and that's mostly as a result of these victim witness programs. So one thing we want to think about too is how we can protect victim witnesses from intimidation. Okay, things to think about here is, being intimidated by the offender, their family or acquaintances, gangs they might belong to, or even their own family trying to have them drop charges due to cultural issues. Here we could see some information about trends in the fear of reprisal as a cause of non-reporting, right? So when people choose not to report to the police because they're fearful that someone is going to, take some kind of reprisal action against them. And we can see this through a period of years here for our four major, for four violent crimes here: rape, robbery, aggravated assault, and simple assault. Things a prosecutor should offer to the victim: protective services, how to get their phone number changed, changing door locks and alarms, additional police patrol, orders of protection, restraining orders, the ability to relocate, and in some cases, in really serious cases, victim witness protection program. We also want to think about when prosecutors dismiss or reject charges, okay? And that happens based on several issues. Not having enough evidence or witnesses being unreliable. Also, it's not just the prosecutor's office that impacts that, but how the police operate, other people in the prosecutor's office, the defense team, judges, community leaders, media. These are all people that can affect whether or not the prosecutor decides to move forward with charges, to either dismiss them or reject them. Some survey research has shown that nearly half of all cases that were solved by arrest were not carried forward. So that means they were rejected by the prosecutor, dismissed in court by a judge, or diverted out of the system. Another thing prosecutors do is negotiate plea bargains. We're all familiar with the idea that a plea bargain is when a defendant agrees to plead guilty in exchange for some type of consideration. Usually the charges are reduced, which means a more lenient sentence. This is how most cases are resolved in the criminal justice system. In fact, 95% of convictions are secured by the accused admitting guilt. So, a couple of things happen in order to then still try to get the charge or the punishment you would like for that offender. People often bedsheet or overcharge so that when they negotiate, it negotiates back down to the charge they originally wanted. Plea negotiations are really a necessary part of the criminal justice system. They reduce the court caseload. Court cases run very slowly or move very slowly, and that's with only 5% of cases going to court. It secures a conviction, which could be iffy if you go to trial. It can also prevent victims from having to testify, and that can reduce emotional distress and trauma, in particular for children and victims of sexual assault. It also reduces the prosecution feeling threatened by involvement of victims. But it also provides no opportunity for victims to have a defined role, and there's no mechanism for victims to challenge a decision made by a prosecutor. So even if you really want to testify in court as a victim and you do not want the prosecutor to plea bargain, that's really not a decision that you have any input in. Now, the defense attorney seems to be the natural enemy of the victim, right? They want to discredit the witnesses. They want to protract the process. Now, the Sixth Amendment does guarantee us a right to a speedy trial, which means states have time limits from the time someone is arrested to when they have to go to trial. But generally, both sides don't want to actually force the issue of the speedy trial. So they might delay things because they hope it'll wear down the witnesses and affect their memory. Make them, become so disenchanted with the process that they don't want to show up. And that eventually this might encourage a victim to drop or reduce charges or refuse to cooperate with the prosecution. In a general rule, the more serious the charge, the longer it's going to take to go to trial. Sixth Amendment also provides that defendants have the right to confront their accusers. Despite all of this, as we know, trials are relatively rare events. Because when we're in a courtroom, it's really a competition between the prosecution and the defense, courtroom tactics seem very harsh and mean-spirited, right? So you're trying to show that the defense wants to show that the victims or the witnesses would have reason to lie. They want to discredit them. That often means the victim gets trashed, in particular in controversial cases. Some conflict results during bail setting and sentencing, and the Eighth Amendment prohibits excessive bail. More than half of victims of serious crimes face the idea that the offender harming them could be out on bail prior to the case being resolved. Denying bail results in the offender going to jail and being punished before they're convicted. Sentencing can be influenced by the victim in a couple of ways. They can convey their requests in writing to the judge, and then they can also allocute. They can express their views orally in person at a sentencing hearing. They might also do this through a victim impact statement. This might be included in a pre-sentence investigation and reviewed by a judge prior to sentencing. The Supreme Court has held that victim impact statements were not admissible in the penalty phase of a murder trial in a 1987 case, but then they reversed themselves in 1991 in Payne v. Tennessee, stating that it is admissible during the penalty phase if execution is an option for the jury. So if during that penalty phase, the death penalty is on the table. These are not widespread. These are not in practice on a widespread basis for judges. The Sixth Amendment does guarantee a defendant that he be judged by a jury of his peers. And there is issues and questions regarding the victim-juror relationship. Victims influence outcomes because of their emotions, right? So when we see somebody and their testimony is really impactful on us or very emotional, that might impact us. Things we're looking at then is which jurors will accept and trust the victim testimony. Jurors themselves may have been victims of serious crimes, and that may impact how they see the victim's testimony and their thoughts and their ultimate decision about the case. Jurors may also consider victims' characteristics and status when making accusations and determining a sentence. Victims are, however, more likely to have contact with probation and parole agents than prison officials. Victims often want two things from these people. They want to know when offenders are on probation or parole to be protected from harm and harassment. And if there's been court-ordered restitution, they want it given to them in a timely fashion. Corrections are also supposed to keep the victim advised of an offender's address. One of the ways you could do this is through the Vine system. And if you Google this, you can go online and you can actually sign up to receive notifications whenever someone's custodial status has changed. So if somebody is released from prison, it'll send you an email, give you a phone call, and let you know that that's happened. Parole boards often receive criticism from victims and victim groups because generally these parties are opposed to early release. They often want parole abolished, and they often support determinate sentencing. So when we know exactly how long a sentence is. So serving 5 years as opposed to 5 to 10. Parole boards do provide victims an opportunity to appear at parole hearings, but very few victims take advantage of this. The victim impact statement is in the offender's file, and the parole board can review that when they make a release decision. Now, the 14th Amendment promises, quote, equal protection under the law, unquote, for all citizens. But are all victims handled equally? This idea of differential handling still needs to be researched again to see if it still persists today. So what are some findings of policy decision impacts? There's no substantial changes in outcomes resulting from the implementation of victims' rights. Insiders, right, so people who are involved in the case and involved in the system, still resist interference by outsiders, meaning victims. Victims still don't have any constitutional standing, so they can't sue for damages for the rights being ignored or violated by the criminal justice system. So a lot of people feel like these victims' rights are just lip service, paper promises, that there's not much substance behind them. By 2011, there were 12 legal clinics across the country who were trying to boost compliance by uninformed criminal justice officials, basically boosting compliance with these victims' rights. And that wraps up this chapter.